Each year, the graduating class elects a member of the faculty to speak at their commencement, and the class of 2016 has selected one of Yale's most intense and brilliant lights, Stephen B. Bright, the Harvey Karp Visiting Lecturer in Law. Steve is a devoted lawyer, a tenacious advocate for justice, and a superb teacher. For decades, he has led the Southern Center for Human Rights, an organization dedicated to those whom our system of law has condemned to death. Steve has been a member of our faculty since 1993, teaching the subject of capital punishment and supervising individual students in the representation of condemned prisoners. And to put it very simply, Steve is a force of nature. He labors with terrible intensity to defend those who lack the resources to defend themselves. Steve has cajoled in the past, Steve has cajoled the Supreme Court to make sure defendants are heard by a jury of their true peers. He has pushed state legislators to create adequately staffed offices of public defenders. He has breathed life into the promise of Gideon versus Rainwright, working every day to ensure that indigent defendants will be represented by capable lawyers. And just this morning, in the case of Foster versus Chapman, he won a decision in the United States Supreme Court and that decision set aside the conviction of a defendant who had been found guilty by a jury from whom African-American jurors had been struck with deliberate discriminatory purpose. Steve is beloved because he believes that the law can be used for great good, as you saw this morning. Of his seminar on capital punishment, one student has said, and I'm quoting now, "If this were a required course, we'd probably live in a more sane and just world." These feelings run so deeply that today will be Steve's second commencement speech at Yale in the last 5 years. And one cannot ask for a more eloquent affirmation of Steve's place within this institution. Year in and year out, Steve's students remember him with awe and appreciation, and the class of 2016 is no exception. Despite his tremendous passion and his outsized accomplishment, Steve knows that his mission is too large to be completed in a single lifetime, and he accordingly treats his students with the respect due to potential successors. He learns his students' names immediately, he pores over their papers with a red pen, and he looks each of them in the eye and shakes their hand before class, and the results are astounding. Students describe him and his courses using phrases like, "It was the best course I took at the law school," "I don't mind using superlatives with Stephen Bright," and "He is the most human professor, warm, caring, funny, and engaged." It is no surprise, therefore, that Steve has inspired countless students to go on to pursue his noble work, the kind of work that Steve has been doing every day since he was handed a diploma of law on a stage like this one and understood the power that he grasped in his hands. So it's my pleasure to introduce this year's commencement speaker, Professor Stephen Bright.
Thank you very much, Dean Post, and I'm most grateful to Robert Post for so many things during his deanship, but I appreciate his eloquent comments and his effort to make it appear that I really belong here. As most of you know, when Guido Calabrese invited me to come here, it was sort of like opening the gate and letting a mule onto the track at the Kentucky Derby. Ever since then, like the mule, I've never really known if I belonged there or not, but I've benefited immensely from the associations with you and with this great faculty. And it's a great honor, and I want to express my deepest and most heartfelt thanks to you, first of all, for the honor of being able to make a few remarks as we celebrate all that you've accomplished here and as you look to the future in the law. It's been an honor for me, more than I can say, to teach so many of you during the last 3 years, to get to know so many of you outside of my class, like John Raphael. You don't forget, you know, people you meet here. And to work closely with so many of you on matters of life and death, both here at the law school and at my program in Atlanta. 5 people graduating today: Michelle, Jessica, Ajay, Robert, Tyler. Thanks to them and thanks to their work, both in Atlanta and here, there's one less person facing execution in Georgia today. And there's a 7-1 opinion by Justice Roberts saying that this kind of racial discrimination and striking people from juries will not be tolerated. I have enormous respect and affection for you, and I'm overwhelmed that you would give me this opportunity. Thank you. Second, I want to congratulate you, your families, your partners, your teachers, your friends, everybody who has supported you throughout your life and at different times in your life and have brought you to this place where you are today. I hope you have a wonderful celebratory day that is joyful in all regards and that it launches you into a meaningful and rewarding life in the law. Dean Post has talked about some of the great global issues that face us. You have been awarded your degrees at a time, as he mentioned, of great polarization in our politics, unconscionable inequity in the wealth of people in our society, an enormous and growing gap in the access to justice for poor people in all kinds of cases, and a continuing failure to end racism in our society and racial discrimination in our courts. And responding to these problems is the collective responsibility of all of us in this society. As members of a society committed to the rule of law and the principles of the Constitution, including equal protection for all. It's particularly the responsibility of lawyers, because lawyers have a monopoly on the provision of legal services, and with that monopoly comes the responsibility to see that the legal system works for everyone. The lives of many people depend upon it. The lives of many people depend. Whether they're being treated fairly, whether they're safe, whether they will have hope and opportunity, whether broken people will be made whole again. And the credibility and the legitimacy of our legal system depends upon it, working for everyone. But as we know, lawyers and the legal system are increasingly beyond the reach of some of those hurting the most and some of those with the most compelling needs. Those facing evictions from their home, those who are the victims of domestic violence, the parent who's about to lose a child in court and has no lawyer to accompany them to court, veterans suffering from trauma and all sorts of other things and encountering all kinds of legal problems, those with mental disorders and intellectual disabilities who've been abandoned to the streets and to the jails and the prisons. Lawyers are beyond the reach of most of those facing deportation, even children unaccompanied by any adult, to a place where they might face danger and even the loss of life. You know what a difference a lawyer makes in these situations because so many of you have made a difference in these and other areas. I think it's so exciting today that 4 women, including 3 graduating today, The children and grandchildren of immigrants and refugees have started the Asylum Seeker Advocacy Project. They have already helped stop the deportation of hundreds of Central American refugees. Many of you have been involved as volunteers, and they will continue to represent individuals seeking to be freed from detention they were or beyond redemption. But you know, most of us know, that they're not super predators and that they're not beyond redemption. Most of us know a young man who at age 16 was arrested for carjacking, convicted, was held for 8 years in prisons in Virginia, including Virginia's infamous Red Onion State Prison, a supermax prison that prison officials said was built for the worst of the worst, for inmates who supposedly were so dangerous that it was better to forget about rehabilitation and simply warehouse them. That was Dwayne Betts. Dwayne wrote about his experiences in the Yale Law Journal. He said, and I quote, "They tossed me in a cell with a door so thick that no sound escaped. I was 16 years old. Each morning they took the mattress from me so that I could not sleep during the day." How do I explain this? "Each day I lost a little bit of what made me want to be free. These were the longest days of my sentence. One afternoon, in a fit of panic, I slammed my fist against the wall. I thought about suicide, and I almost disappeared." And yet Dwayne Betts survived the ritual degradation of prison. He started a book club for African-American youth called Young Men Read. He wrote books and poetry, as you know. He graduated from the University of Maryland. He got married. He's bringing up 2 beautiful children, 2 sons, who just walked across this stage, and now he just walked across this stage, a graduate of Yale Law School. His experience reminds us that even those who have broken the law need representation that treats them as individuals, that examines who they are, precisely what they did, and assesses what they can become. That recognizes that they are much more than the worst thing they ever did in their life, and that they are not defined exclusively by one terrible mistake. Not everyone has Dwayne's extraordinary gifts of intellect and resilience. As he described in his article, many did not survive the brutal experience of prison. And that's all the more reason to follow his example in working with children, because we must never give up on our children. The child that some lawyer represents today and keeps from being expelled from school, keeps from being sent to some juvenile prison, that child may someday graduate and make immense contributions to her community. All of us as members of society and as part of the legal profession must also confront, as I said earlier, the continuing influence of race in the legal system and the exclusion of people of color from the decision-making process within it. The courts are the institutions in our society least affected by the civil rights movement. There is, as there should be, great attention to the law enforcement practices that have resulted in many black men, unarmed, killed by white police officers. It's a very long list that includes 17-year-old Laquan McDonald shot 16 times by a Chicago police officer just 6 seconds after he got to the scene. 12-year-old Tamir Rice, who was shot to death within 2 seconds of the lawyers getting to the playground where he was playing. Eric Garner, killed in a chokehold for selling loose cigarettes. And a long and sad and tragic list that goes on from there. But there must also, and we need to be discussing those practices, the policies, the cameras. We know so much today, and we wouldn't know what we know in those cases, just as we wouldn't know so many people are innocent were it not for DNA evidence. We would not know what happened in many of those cases were it not for cell phones and for other surveillance equipment. 14 police officers wrote reports about Laquan McDonald, and not a single one told the truth. Not a single one. But we've got to worry, too, about what happens after people get arrested, after they get in the court system. Because now there's a whole bunch of discretionary decisions that are going to be made. Whether it be released on bail, that can ruin your life if you're not released on bail. What charges will be brought? Whether a competent lawyer will be appointed. Small chance of that. What plea bargain will be offered? Whether people of one race will be excluded from participating, or one gender, in striking the jury. What sentence will be imposed? These decisions, each of these decisions, and not a lot of others, are all influenced by race. They're influenced by race, it's undeniable. And in many courts, white people make these decisions in a system that is dealing primarily, and in some cases just about exclusively, with people of color. 95% of the nation's 2,400 elected state and local prosecutors are white. 79% of them are men. I can tell you from personal experience, quite a few of that, a substantial number of those are pretty mean white men. Not all of them. And about 86% of state trial judges and appellate judges are white. People of color, just as in the case decided by the court today, an example of people of color routinely excluded from juries because of their race. In the case of Tim Foster, an African-American youth that so many of you worked on, the prosecutor struck all 4 African-Americans and then urged the all-white jury to send Tim Foster to death row to deter people in the projects. Tim Foster and his family lived in the projects. 90% of the people who lived in the projects were African American. There's no secret about what that call was about. It's a matter of the greatest urgency that I hope you all will take on in your careers to make the courts look like the people that come before them. Regardless of what you do. And the reason for this, of course, has been the distance. You know, that most those lawyers have so often been white, male, reasonably well off, living in the suburbs or wherever. And those most desperately in need of legal services are predominantly racial minorities, poor people, working class people. And those who have the legal skills aren't near them, don't know them, don't identify with them, and don't prioritize helping them. But we have to do that. I urge you, regardless of what you do, to be engaged with these people that I've described and with these issues. I encourage you to spend time in proximity to the injustices and the suffering. From time to time, no matter what you do, get in the trenches. And I want to particularly urge you, represent clients. Represent these people that I've described, no matter how great a departure that may be from what you do the rest of the time. No matter how prosperous or powerful you become, spend some time in the jails, in the homeless shelters, in the housing projects, and other places where you find the weak and the injured. Spend some time in the courtrooms, from the lowest municipal and administrative courts on up. The courts that people have the most contact with are the municipal courts, which, as the Justice Department found out with regard to Ferguson, are not about law enforcement, not about upholding the law. It's about revenue collection. And these are cash cows that process people like fast food restaurants with scant attention to them as individuals. And they're filling up our debtors' prisons as they do so. The great privilege of being a lawyer is that you can offer a helping hand and lift up people in ways large and small. You can provide a voice for those whose lives hang in the balance, but speak in voices too faint to be heard. Last Friday, my colleagues at the Southern Center secured the release of Kiana Adams, who has a high-risk pregnancy, is 8 months pregnant, and due to give birth at any moment. She'd been sleeping on the floor of the Muskogee County Jail in Columbus, Georgia. A judge sent her there because she couldn't pay some fines on some traffic tickets after she lost her job at Walmart. In that case, 2 lives hung in the balance. And we were able to secure her release within a day of knowing about her situation. That's what you can do as a lawyer. Of course, you won't be successful in every case, with every client, but you can always encourage and lift up people. You know, listening and counseling always helps people in distress. We know that. We've all been in distress. But listening and counseling by a lawyer really helps people with legal problems, even if it turns out that's all you can do. And you can bear witness to injustices and hope that it will eventually bring them to an end. 2 weeks ago, the world lost a great visionary lawyer, Michael Ratner, who spent much of his time with the Center for Constitutional Rights. In his remarkable life in the law, he held the U.S. government accountable when it went to war illegally, when it tortured people, when it withheld information, when it limited the rights of a free press, and in countless other contexts. It was observed that his special gift was the ability to turn an urgent problem into a meaningful, hard-hitting lawsuit. He took on the prison at Guantanamo twice. In one case, he and Harold Coe and the Human Rights Clinic here represented Haitian refugees that were being held there. When people were sent to Guantanamo after 9/11, he knew it was an attempt to place them beyond the law, beyond the courts, beyond the media and the lawyers. And he challenged those detentions, and he prevailed in both cases. And after the second, he was asked what he thought his chances were when he filed the suit. And his answer was none whatsoever. This suit was filed 100% on principle. Remember that, 100% on principle. The lesson there, take risks. Get over your risk aversion. I encourage you to use your knowledge and the privilege you have to take risks for whom those playing it safe was never an option. Your greatest accomplishment may be the result of the greatest risk you take. Harold Coe recalled being aghast in the first Guantanamo case when the United States government filed a Rule 11 motion against them. And Michael Ratner reassured him. He said that the other side always files a Rule 11 motion in my case. That's no problem. It's a badge of pride. Don't worry about it. The lesson there, do not be deterred by the threats of the powerful. Seema Ahmad, who worked at Guantanamo with the clients and their families, said she learned from Michael Ratner that one of the most spiritual, fulfilling experiences is to stand with someone who has no one and to see them as a human being and to learn their story. It's about the clients. At the end of the day, it's about the clients. The people confined to Guantanamo, the people facing deportation, the people on death rows like Anthony Ray Hinton, the woman with a problem pregnancy on the floor of a jail somewhere, and countless others for whom equal justice is just a promise to the ear to be broken to the hope, a teasing illusion like a generous bequest in a pauper's will. We've got to make law a reality for those folks. Let me end with this, and those of you in the class already have heard this, but less than 50 years after the end of the Civil War, two extraordinary black men, Noah Pardon and Styles Hutchins, had established a law practice in Chattanooga, Tennessee. Right there at the border, Tennessee, Georgia, segregated. They were called upon in 1906 by the father of a black man, Ed Johnson, who had been convicted for the rape of a white woman and sentenced to death. Ed Johnson was almost certainly innocent in that case. His father asked Noah Pardon, who was the first lawyer he saw in the office, he asked him if they would take the case and try to save his son's life. This is heavy duty. And Noah Pardon conferred with Hutchins, Styles Hutchins, his partner, who said, "Of those to whom much is given, much is expected." They took the case. And almost immediately their homes and their law offices were attacked. Noah Pardon took a train to Washington, D.C. and presented the petition for a stay of execution to the first Justice Harlan, who granted it and stayed the execution. And that night, Ed Johnson was lynched. A mob broke into the jail and took him to the bridge in the middle of town there in Chattanooga that goes over the Tennessee River. They put a noose around his neck, but before they hoisted him up, Ed Johnson said, "God bless you all, I am innocent." And he was hoisted up, and his body was riddled with bullets. Days later, the home of a black minister who had preached a sermon against lynching was burned down. The offices and homes of Pardon and Hutchins continued to be attacked. And within 2 weeks, Noah Pardon and Styles Hutchins left Chattanooga and never came back. And what struck me and strikes me to this day is that when they were deciding whether to take that case, they had to know that if they accepted the case, nothing would ever be the same again. Everything they had worked for, the lives that they had spent building what they had, a law practice by two African-American men in the Deep South at that time, it would all be up for grabs. They might even be lynched themselves. But it wasn't a tough call for Styles Hutchins. Of those to whom much is given, much is expected. Styles Hutchins recognized the privilege of practicing law, and he understood that the rights of Ed Johnson meant nothing without a lawyer. We are not asked today to make decisions that hard, but we are equally aware of needs so compelling. So no matter what you do, spend some time, as I said, at the homeless shelters. Stay in touch with the legal services offices, the public defenders, the public interest projects to see what the needs are. And remember Styles Hutchins. Of those to whom much is given, much is expected. Good luck and Godspeed.